saw the former Attorney General, or the immediate past Attorney General, Godfrey Yeboah-Dame, put together a piece insinuating what has been done today and also advocating for possible release of William Ato Essien. He's not alone in this. A number of people have been speaking in this particular direction. But earlier today, the founder of defunct Capital Bank, William Ato Essien, has been granted bail by the Court of Appeal. Now, this comes 21 months after he was sentenced to serve a 15-year jail term for his role in the collapse of the bank, Capital Bank. Now, let's get the basis to this. Recall exactly how this case has traveled over the period. And within this 21 months that William Ato Essien has been in the coolest, serving this jail term of 15 years, what has been happening? Appreciate you. Dennis Wedam, Esquire, thank you for joining us. Perfect. Now, let's recall a bit and go back, chronicle the events, set the foundation for it, okay?
Yes.
How did this case start?
Well, so this is one of the cases that stemmed from the banking sector cleanup. And recall Capital Bank was one of those banks that the Bank of Ghana revoked its license over some insolvency and then regulatory matters. It didn't end there. There were some persons who were personally held to account for what has happened to the bank. One of such persons was the then managing director and the founder of the bank, Ato Essien, who was charged with 26 counts of stealing, money laundering, and conspiracy. Fast forward, we progressed into trial. Witnesses started to testify. Initially, he pleaded not guilty to these charges. However, things would take a different turn by December 2022, when he pleaded guilty to stealing some 90 million as part of a plea bargain. Now, what that meant was that, yes, he says, I'll pay this amount of money, and then I will not be subjected to a custodial sentence.
So the plea bargain we're seeing now with the now current Attorney General,
yes,
entering into some plea bargain agreement and then arrangements, not specific to Covenant 4, but we've seen in previous times. He's kept talking about some arrangements he's done with some other persons who have also now agreed to serve as prosecution witnesses in some of the previous cases.
Precisely so.
So it's a path that has been taken.
That is allowed. There's a part that allows you to plead guilty and make restitution, and there's another part that allows you to elect to testify so that you don't be prosecuted. That's where the Attorney General refers to that as an NPA, a non-prosecution agreement. Yes, but the point has to be made that at a certain point, there was an agreement that he was going to pay 90 million as part of the plea bargain deal. And in so doing, the settlement agreement was to the effect that he would pay the 90 million in 3 installments. First installment, 30 million, was paid shortly after the plea deal. So what it meant was that 60 million was outstanding. Unfortunately, he failed to meet the payment schedule after the first 30 million had been paid. The court threatened that if he doesn't pay up the amount, he was going to be put into prison. Fast forward, he was given a grace period. Unfortunately, he could not still meet the payment schedule. And then he was jailed for failing to honor that payment terms and sentenced to 15 years in prison. Now, what we have seen happen after this was initially a call from some members of the public. I think key person to have made that call publicly was KSM when he made that plea to the president for clemency. He cited some health reasons. What we are learning today is the fact that his lawyers, at the time when that plea was made, there was argument that, yes, if it is indeed the case that he's not guilty of the offense, but it wasn't just about the health concerns. There was also a conversation about the fact that he may not have been guilty after all. And the conversation was that if that be the case, there is a legal route for you to want to challenge your being in custody or your being in prison. Now we have seen that legal step being taken by his lawyers. They filed an appeal. And then before that appeal, they prayed to the court for bail pending that particular appeal. Graciously, that that application was granted, and now he's been granted bail to a bail sum of 10 million, 2 sureties. He had to surrender his passport and also to make some frequent report to the authorities that be as part of the bail conditions. So, Alfred, this is where we are. However, in the wake of that issue that you brought up, the Covenant 4 issue, where the Attorney General has entered a nolle prosequi in respect of some charges that were leveled against him. In fact, he and 7 others were going through trial for similar offenses That is to say, it also came out of the banking sector issues. There had been conversations about the possibility of then also having to relook this man's case. Because the argument, and principally the person who makes that argument, is the former Attorney General. When yesterday he wrote quite a lengthy piece to raise some concerns and even cite examples of how Ato Essien in his case, like we indicated, had paid some 30 million. And in fact, before he was incarcerated, he had paid an additional 9 million. So in all, he paid 39 million.
Out of the 90 million?
Out of the 90 million that he had agreed to pay. And even with that, he still went into jail. So it was the contention of the former Attorney General that now seeing what we are seeing, the Attorney General now enters into an agreement with Dr. Dufour and then the others in that particular matter to recover 60% of the money that the state had lost in that particular banking sector issue. His argument is that it is appropriate that when you look at it within that light, then maybe Ato Essien should be freed. And this is just a part of the exact text that he put out. After making the analysis, then he comes to say that I dare say that on account of the resetting of prosecution we are witnessing, there's no justification for Ato Essien to be in jail. Free Ato Essien now. This was only yesterday.
And then now we're seeing the development of he being granted bail.
But
the bail has nothing to do with what this...
Exactly, that's the point I'm making. But just to put the matters into proper perspective as to how the conversation has progressed from people making calls for his release on health grounds and also on matters that relating to he may not necessarily have been guilty, and then also seeing the nolle prosequi and the conversation now coming from the former Attorney General making that comparison. That is the context within which we're having the conversation, but not to say that this post that he made had anything to do with
what's happened today.
What happened today.
It's very, very important distinction that you need to make, and I appreciate you for this.
Thank you so much.
Stay with me, Dennis.